Greg, Jess, just so you know, there's a live stream camera right up there. Well, welcome everybody. On behalf of the American Enterprise Institute and the Scalia Law School's Boyden Gray Center for the Study of the Administrative State, I'd like to welcome you for a conversation about the Supreme Court's new year and the broader debates around the Supreme Court. My name's Adam White. I'm a senior fellow here at AEI and co-director of the Gray Center. It's nice to get to welcome everybody on behalf of both groups. We're really lucky to be joined by a great panel of experts. I'll introduce the speakers briefly and then turn it over to our moderator. First, Jess Braven is the Wall Street Journal Supreme Court correspondent and author of several books on the American justice system. He was formerly the Wall Street Journal's UN correspondent. We're also joined by Greg Storr. He's Bloomberg News' Supreme Court reporter. He's been doing this since 1988, which makes me wonder, do you have life tenure like the justices?
98.
1998?
Yeah.
What did I say, 88?
Not quite that old.
He's been there since 1928. He's the former host of Bloomberg Radio's Bloomberg Law program, and he's the author of a book titled A Black and White Case, How Affirmative Action Survived Its Greatest Legal Challenge, published in 2006. We're also joined by my colleague, Jen Mascott. Jennifer Mascott is assistant professor of law at the Scalia Law School, where she also co-directs the Boyden Gray Center. And she leads the center's Separation of Powers Clinic, which files briefs in a number of Supreme Court and other federal cases. She clerked for Justice Thomas, and before that, for then D.C. Circuit Judge Brett Kavanaugh, and she served in senior positions in the Justice Department. Am I able to mention your newest? And she's also now a contributor to NBC News. And finally, we're joined by John Yoo. John is a senior fellow here at AEI, a professor of law at the University of California, and a senior fellow at the Hoover Institution. He's also the author of several books on constitutional law, served in the Justice Department, the Senate Judiciary Committee, and before all of that, he clerked for Justice Thomas and the late Judge Larry Silberman. And John will be moderating our conversation, so I'll turn it over to you.
Thanks, Adam, and thanks everybody for joining us here and online. I thought we'd start out with a very broad question. Maybe you could go ahead. What is your sort of 10,000-foot view of the Roberts Court this last term? Maybe also in the context of the previous term, do you see continuity, or is there a sharp break with the Trump justices? What do you make of the resolution of affirmative action, abortion, gun rights, these major issues that have been with us for decades now? Do you see the court continuing in this direction? Is there going to be a change of direction? So why don't you go first, Greg?
Well, I certainly don't think we've seen a sharp break. I mean, let's just go back to June of 2022 when we had the Dobbs ruling, the Bruin gun rights ruling, and the West Virginia EPA climate change ruling. And all those kind of came right at the same time at the end of the term. And I think for most of us, they were all kind of like maximalist rulings in terms of what seemed like what the court might do in those cases where conservatives pretty much got everything they could reasonably have hoped for in those cases. And I think that kind of built up this expectation among, especially people on the left, that, oh my God, this court is going to just, steamroll over everything. And then last term, we saw a little more of a mixed bag, where they upheld the Indian Child Welfare Act. They did not, embrace a sweeping version of the independent state legislature theory on election law. They issued what I thought was a very surprising ruling on the Voting Rights Act in the context of redistricting in Alabama. And there we saw that this court is not a monolith where conservatives win everything. But of course, you look at the term as a whole. I mean, the affirmative action rulings overturning affirmative action they didn't explicitly overturn the Grutter decision. They didn't say that, but essentially they abolished the use of race as a factor in college admissions. You look at several other rulings that are slipping my mind right now. And it's still a court that is going to give conservatives what they want most of the time. So now we jump ahead to this term. We'll talk more about the cases now. And you look at the cases and you can see some where, chances are conservatives are going to get what they want, but they're certainly not going to get everything. And certainly some of these cases out of the Fifth Circuit, I think, could well push some of those justices that we think of as a little more in the middle of the court, Kavanaugh, Barrett, Roberts, may push them out of their comfort zone, and they may not be willing to go as far as the Fifth Circuit. So, it's a court that's moving to the right, but not necessarily in a straight line.
Jess?
Well, I of course always agree with Greg. I would just add a few thoughts to that. At the end of the 2022 term, there was a lot of discussion about legitimacy of the court. Particularly Justice Kagan questioned whether the majority was being consistent with the way it applied its doctrines and its approaches to the law, and suggested it was kind of odd that the doctrines seemed to shift to always result in the Republican Party preferred outcome. This year, I think we saw, at least from the perspective of the Chief Justice, and I don't know how conscious it was, but an effort to show that while it is a very conservative court, it's not a Republican Party court. And that's looking at the distinction between the voting cases and the other cases like affirmative action and the Clean Water Act case. On those decisions, and in most of the decisions the court made, the outcomes were very conservative. But as Greg points out, we had two election cases where I think some Republican Party activists were surprised and disappointed that they didn't get what they wanted from the court, particularly a rollback of Voting Rights Act precedents that prevent vote dilution of minority voters and take explicit account of race in doing that. And of course, the state legislature theory, which has implications for the Electoral College as well. So it seemed that the idea that this court is simply functioning in what is in the interest of the Republican Party, you could not say that based on what the court did last year.
Jen?
No, I don't think the court last term had a sharp break from its past trends. And I would encourage everybody not to think of the court in such political party terms. I mean, I think for years the court has not been lining up necessarily with one political party or the other, and even right after being confirmed, essentially, you saw, for example, some of the last president's appointees issuing decisions that were not necessarily most immediately in the bottom line favor of the president that appointed them. Certainly back in 2020, the court is obviously being handed significant issues to resolve with affirmative action, privacy, abortion cases, guns, but that's really because, for one thing, for decades, the court was moving in a particular direction. And so I think one way to look at it is it's just starting to really re-examine whether some of the courts, perhaps power grabs of decision-making authority in the middle to late 20th century, early 21st century, whether there needs to be sort of a correction and reevaluation of the court's proper role. And then with the cases that we've got before the court this term, the agency cases coming through the Fifth Circuit, it's really about the breadth of power being exercised at the federal level, across the board, but in particular with administrative agencies and the executive branch that I think is teeing up some of these big cases and these big challenges. And it's as a direct result of the agency's action and choices in a lot of cases that they're facing so many big challenges that are appropriately perhaps reaching the court.
I just say, in terms of the broader context around the court, I'm keeping an eye on three big picture trends. First, I think especially in the aftermath of the affirmative action cases, we see an interesting turning point in the court's modern history. For the last few years, the big cases have been the abortion-focused cases, culminating with Dobbs, and then the cases about racial distinctions in law, particularly with affirmative action. And those two sets of issues were really fundamental to the history of the rise of the modern conservative legal thought, textualism, originalism. Those were two of the galvanizing issues. And now that they've been, nothing's ever permanently decided by the court, but now that they seem to, in this sort of chapter of those cases has closed, it's interesting to see what the court will be focused on the most. It doesn't get to, I guess it gets to pick its cases through cert, but the pool of cases that arrive to it be interesting to see what they consist of. We'll probably be focusing more on issues out of administrative agencies. I mean, again, co-directing a program on the administrative state, when all you have is a hammer, everything looks like a nail, I guess. But it's hard not to look at the court's modern docket and be struck by how administrative agency heavy the court's docket is going forward. If the administrative state is sort of the center of gravity in modern policymaking, it's going to be the center of gravity in the court's docket. Related to that, my second point is just that even constitutional issues have more and more of a flavor of I wouldn't say administrative law, but questions about administrative discretion. When you think about the Bruin case, the big Second Amendment case, it was a case about the Second Amendment, but it was also a lot about the New York licensing authorities' discretion, and the court was worried about that. Even a case like Masterpiece Cake Shop, it was about the First Amendment and religious liberty a few years ago, but it was also a lot about what the Colorado regulators were actually doing there. And so more and more of our constitutional issues are taking on this sort of administrative discretion aspect. And so I think that's important too. And then my third point is that often the most interesting debates among the justices are not so much disagreements about interpretive methodology. I mean, of course that's there in the cases, but you get so many interesting discussions, debates among the justices over the pace of the court's work, how quickly they move to change a line of precedent, whether they're going to overturn it a little bit or not at all or a lot, how quickly they should intervene when they're asked, when they receive emergency motions. The pace of the court's work in a couple different dimensions is so important, and I think it gives rise to some of the most interesting debates among the justices, and it probably will continue to do so.
So people probably don't remember John McLaughlin when he was the moderator, but he would then say, "You're all wrong."
So what's the correct image?
No, I'm just kidding. I actually look at it as a little bit like you, Adam, that I think the affirmative action and abortion cases wrap up the Nixon, Ford, Reagan effort to change the courts. I sometimes wonder if people in the 70s who were around when those decisions, Roe versus Wade and Bakke, were made, would they have been surprised that we would still be arguing over those issues 50 years later, right? It took 50 years for there to be a kind of change that the political system was trying to achieve for many decades, many presidential elections. So the one thing I was trying to apply was, now that those questions we've had with us for 50 years are kind of coming to a close, what are the new issues that the Roberts Court is going to address? Keep in mind the Roberts Court is almost at its 20th year. The Rehnquist Court, which came before it, which was a long-lived court, was, I think, 29 years. So we're maybe about 2/3 of the way through the Roberts Court. What is the Roberts Court going to focus on now that these old fights have kind of come to an... Although you might write another book on affirmative action. They're still... Yeah, very different book. So let me turn to Jen, maybe. Looking up at the term coming, starting on Monday, what are the cases or issues that you're really focused on that you think are going to be important for the Roberts Court, maybe important for the direction of constitutional law?
Sure. Well, to be fair, I mean, when you're saying what issues is the Roberts Court looking for, I mean, of course, it does have discretion in its cert docket. But again, it is responding to the cases that are brought to it. And those cases are coming up based on what litigants are challenging, perhaps where. And it's a little, premature in a sense, right? Because they actually haven't filled out still a lot of their docket for this upcoming term. So I think that at the last count, we had 23 cases this term. So presumably they're just about 1/3 of the way there, depending on how you count in recent years. But already one interesting trend is they have a lot of administrative law cases this term. So looking at separation of powers. So I do think one area where we will look back and see Chief Justice Roberts having written a lot and made a lot of strong statements and perhaps pushing back on decisions from the prior century will be in the area of separation of powers, executive power, administrative agency authority. In the past, some of the big agency cases have been about supervisory authority and how agencies are supervised, the president's role over them. This term, we're really mostly looking at slightly different issues about how Congress is interacting with agencies and structuring them in the first place to make decisions internally, and their subject matter authority a little bit. So a couple of the biggest challenges. One is coming from the Fifth Circuit, SEC versus Jarkissi. in which the Fifth Circuit found there to be 3 constitutional violations related to the SEC's exercise of authority and adjudication that are before the court. I would be really surprised, you all tell me if anybody here disagrees, if the court makes some kind of significant ruling on all 3 of those questions and changes dramatically our understanding of any way in which agencies are operating. But essentially, basically the Fifth Circuit found that the SEC, when it engages in internal adjudication, has a little bit of a supervisory problem because the administrative law judges who are hearing the dispute in the first instance are subject to too many layers of removal protections. So the court in the past ruled that essentially that you can't have double for-cause removal protections. You can't have an agency official who has tenure protection who's subordinate to an agency official with tenure protections. However, in standard, perhaps Chief Justice Couching style, that decision or that holding was sort of by its terms limited to the grand authority that was being exercised by the agency officials at stake, and it was not, they kind of carved out agency adjudicators. So arguably the Jarkissi versus SEC litigations raising this question in different contexts, and so maybe the court will find the issues here to be different ones, and their prior precedent not necessarily extend here. That's the first issue. And then the other issue is more fundamentally about what issues agencies should be adjudicating internally. So when an agency issues regulations and then begins to try to enforce those regulations, impose penalties, adjudicate whether the regulations have been violated, Congress, at least in this case with the SEC, and some of this is relatively newly expanded authority in the last couple of decades, but the agency could prosecute the charge in an Article III court. So typically, like we would see outside independent tenure-protected judges in the Article III system, perhaps jury trial rights, giving some kind of protection and accountability to the adjudication of the agency's charges. Here, the agency also has the power by Congress to instead choose to bring the charges internally first and adjudicate what kind of penalties should be imposed. And so the Fifth Circuit concluded that there's a tension there with the Seventh Amendment jury trial right, and also actually, interestingly, a delegation problem. So if you all follow administrative agency cases, generally speaking, the court's been very hesitant over the years to be very strict about the non-delegation doctrine, which essentially says that Congress, because it's been vested with all of the legislative authority, has to make the significant policy decisions or legislate, and it can't delegate that legislation power away to administrative agencies. So the court's historic doctrine has been that so long as Congress, when it's legislating, gives another actor like an administrative agency an intelligible principle to follow, it hasn't actually delegated away the power to make new law. It's just delegating away policy discretion. So here the litigant's argument was that because there are separate provisions giving the SEC the power to either go in-house for adjudication or go into Article III court, that Congress hasn't actually given the agency a meaningful standard to use when deciding between the two venues, and so that choice in and of itself constitutes an unconstitutional delegation of decision-making power. So because the Fifth Circuit found problems in all 3 cases, the court's going to take a look and evaluate, whether any or all of those, I suppose, are valid constitutional things. So then we've also got the revisiting of the Chevron doctrine this year in Loper-Bright coming up through the DC Circuit. And I don't know, you want me to explain the Chevron doctrine?
All I was going to say is clearly nothing as important as the Harvard affirmative action case or the abortion case from 2 years ago in Dobbs.
I don't think, no, there's nothing I wouldn't say is interesting publicly, like culturally, but if one is thinking about how the government operates, the court could, in theory, I suppose, broadly pronounce on important issues about how the branches interact with each other in any of these cases. But no, nothing that's going to get people around their kitchen table talking in quite the same way.
I hope they don't talk around the kitchen table the way you just talked about the non-delegation doctrine.
Wait, do tell, John.
No, but please describe the Chevron case. You said Loper-Bright, is it called?
Loper-Bright from the DC Circuit, yes. Well, essentially, the actual facts are not quite as important. Essentially, under the statute, the agency determined to require vessels to take on board inspectors to evaluate whether they violated the law, and they have to pay the salary of these people who are investigating whether they violated the law. And so it's outside the terms, the clear terms of the statutory authority. And so the litigators in the case, Paul Clement, also a fellow former Silverman clerk, and Scalia. Well, you're Thomas. But anyway, fellow Silverman clerk is litigating the case and raised two questions for the court to review. One, under the Chevron doctrine, is this a lawful interpretation of agency authority? And then second, should the Chevron doctrine be revisited or limited? And the court didn't take up the first question, it took up the second. So it wants to revisit this doctrine, which is important because it's essentially the courts saying that they're going to defer to agencies when they interpret the scope of their statutory authority, even on legal questions. And then if it's a broad, vague term in the statute, that the agency will then have discretion to interpret reasonably how its authority exists under the statute. And I think the reason why some folks find this interesting for the court to evaluate is because sometimes it seems on the surface to play into some of the political cynicism perhaps that people have about the court, because it used to be for many years, it was thought to be sort of a Republican-friendly it is an executive-friendly doctrine, but over the years, as agencies have engaged in the exercise of more and more authority, it has become a doctrine that a lot of times folks who you would think are conservative jurisprudentially are really urging the court to reconsider, because it seems as though the court perhaps arguably is abdicating its role to review and closely interpret statutes and instead giving a lot of power to agencies that folks are uncomfortable with these days.
Adam, more administrative law?
Yeah, I guess so. And I will say, the moment I realized administrative law was going to be a huge deal in the Supreme Court years ago was when I realized the word Chevron deference was popping up in conversations with non-lawyers. And usually it's the kind of thing that only law students and lawyers and government agencies would talk about, and judges. But once it entered sort of the popular political conversations, you knew something was gone horribly wrong in America. And so I'm glad the court is hearing that case. I'll be curious to see what the court does with it. It's impossible, as Madison wrote in the Federalist, it's impossible to take all vagueness out of laws, but Congress could do a much better job of writing its statutes more clearly. And until it does so, the courts and the agencies have had to grapple with these questions of deference, and I'm curious to see what the court does. The case I'm watching the most closely involves the Consumer Financial Protection Bureau. It's called CFPB versus Community Financial. It's one of the first cases they're going to argue this year, argued, I think, October 3rd. Tuesday. I'm not an entirely unbiased observer here. A little more than a decade ago, when I was still in private practice, Boyden Gray and I and our colleagues filed the original constitutional lawsuit on this and other issues related to the CFPB. But this particular issue about the CFPB's funding authority has just not reached the Supreme Court until now. So I'm curious to see what happens. The long story short is the CFPB is not funded through annual appropriations or biennial appropriations from Congress. Rather, when in the Dodd-Frank Act in 2010, Congress wrote into, and President Obama signed the law that said the CFPB's budget is determined by the CFPB itself, and the CFPB gets that funding by going to the Federal Reserve. The CFPB is entitled to up to 12% of the Fed's Board of Governors operating budget. So it's a lot of money. I think it's over $700 million a year now. And so that's where the CFPB's funding comes from. And the question is, does that violate Article 1 of the Constitution, which provides that no money shall be drawn from the Treasury except by appropriations by law? And so this case coming before the Supreme Court now raises a few questions. Is this money from the Treasury? I mean, it's coming from the Fed, but by operation of another law, all the Fed's profits have to go to Treasury. And so it's definitely money that's diverted from the Treasury. Then the second question is Dodd-Frank itself an appropriations law? Now, until recently, nobody would have said that. In fact, the CFPB, through its entire history, said over and over again in various reports to Congress, to the public, to the GAO, they said, we don't receive appropriated funds. And that was seen as a virtue at the time by the people that created the agency, because they didn't want this agency politicized, they said. I would phrase it differently. I'd say they didn't want political accountability for it. But either way, until very recently, the agency insisted they didn't receive appropriated funds. Until the Fifth Circuit ruled last year, and before that there was a separate opinion in a different case by Judge Edith Jones, saying actually the CFPB is right. They don't get appropriations, but they're spending Treasury money, and that's unconstitutional. So now the Supreme Court will have to decide whether or not this agency's funding source is unconstitutional. It's interesting in a few ways. It'll be interesting to see, first of all, how the justices grapple with this issue. There isn't really any precedent on this issue. There's precedents about agencies being funded partly by user fees, fees for service, their own operations, but that's not what the CFPB has here. They just have a separate pot of money that they can just reach into for their enforcement actions. So I'll be curious to see how the justices really conceive of this issue from the ground up, how they do or don't distinguish the CFPB from some of the other financial agencies, where they draw these lines, if any. So that's the main case that I'm watching. Can I just say quickly a couple others? Since Chris Scalia is here, he always insists upon a Shakespeare quote, and I think the theme for this year is from Twelfth Night. Some men are born great, some achieve greatness, some have greatness thrust upon them. And we'll be curious to see which bucket the Supreme Court's docket is in
Chris, did
this
you
year.
get that one right?
Was I close? Sure. Nice. Yeah. Because there's a lot of interesting cases on the cert docket and some others that aren't yet there that might get there that I'm keeping an eye on. The first one is kind of a sleeper case. It's called American Petroleum Institute versus Minnesota. It has to do with an arcane issue of civil procedure. When can a case be removed from state courts to the federal court? The case is a climate tort case against API and against oil companies, basically. And frankly, I think like a lot of the other climate tort cases, it's clearly an effort to make federal policy or national policy, we'll say, on energy. But the plaintiffs pled their case very carefully to avoid the case being pulled out of state court into the federal courts. And so this is basically an esoteric dispute over what's called the well-pleaded complaint rule. But in the last couple of years, in a lot of regulatory cases and other cases, the justices have had to grapple hard with substance and form, and really how hard they're going to look beyond the immediate pleadings to try to gather what's really going on in the case, what's the right that's at issue, and so on. And so I'm seeing this as the latest substance over form case, in my opinion. It was a lot like the case last year, a case called National Pork Producers Council. It was a Dormant Commerce Clause case, and we were all waiting to see how did the justices, especially the new justice, one of the newest justices, Amy Coney Barrett, how did she grapple with the federalism issue in that case? And so I'm watching the API case to see how the justices grapple with the specifics of the doctrine, but also the backdrop of what's really happening in and around the case. And the other two I'm keeping an eye on, one is a case called Speech First versus Sands. It has to do with what are called the bias response teams on college campuses. The case involves Virginia Tech, and whether their regulation of student speech violates the First Amendment, whether it chills free speech on campus. Again, this is not a case where I'm not entirely unbiased. The organization, I was on their board when they started up years ago. I'm not anymore. But there's been a number of circuit cases on this issue regarding public universities, and I think the court's going to grant cert. And if they do, I'll be interested to see what they say. I'll actually be at the Virginia Tech game this weekend, so I'll be sure to ask around about it. But that's a case I'm watching. Also watching the social media cases out of the 5th and 11th circuits over whether the states can regulate social media content moderation. There's a circuit split that's going to be interesting. And then the last case in the bucket of greatness being thrust upon the court, I think it's impossible not to be watching the 14th Amendment issue around the presidential election. There's going to be a lot of energy and hydraulic pressure to get that issue of whether President Trump is disqualified from office by operation of the 14th Amendment. I think if that, and John's written about this, I've got some strong views on that issue, but there's a lot of people calling for the courts to decide this issue. Rick Hasen as an op-ed in The Atlantic yesterday or the day before saying the court needs to decide this issue. I think if the court actually gets that case, it's going to be a political fiasco around the court. The court will do the best job it can, but it's going to be chaos. And I think there's going to be a lot of push to get that case in front of the Supreme Court this term before the presidential elections. And I'm very worried about that. And that's definitely being thrust upon the court.
Could I jump in for a second?
Yeah, sure, go ahead.
Just to pick up on something Adam said that Jen also alluded to in talking about her cases. This is going to be a term where we're going to have a remarkable number of cases that got to the court because the Solicitor General filed a cert petition. It's so in two of the administrative law cases that Jen talked about, the SEC case and the CFPB case, the gun case that I'm sure we'll talk about, involving whether somebody who's subject to a domestic violence restraining order still has full Second Amendment rights. There's a case that I would think our administrative law experts will be interested in too, involving bump stocks and whether ATF can classify bump stocks as a machine gun and therefore make them illegal, where there's a pending cert petition that the court will probably act on. It's scheduled for its next private conference. And an awful lot of these cases are ones that are coming out of the Fifth Circuit. And when it happens that a federal appeals court says something the federal government is doing is unconstitutional or exceeds agency authority, and the SG goes to the Supreme Court, basically the Supreme Court has to take that case. I mean, almost inevitably, that's the case that's thrust upon them. So, I mean, I think of some of these cases this term as different from one another. The Loper-Bright case is a case where the court, it's clearly an issue that they've cared about a lot, and they made a decision, we are actually going to think about whether to overturn Chevron. The other cases, the Appropriations Clause, I don't know what they think about that, because it was a case where, as you said, there's not a whole lot of precedent, they haven't written about it, and they pretty much had to take it because of the context of it. So that, to me, is one of the really interesting dynamics of this term, and I'm sure there are a couple cases I'm forgetting as I'm talking about this, but, just one more, the mifepristone case, where the question of the FDA's approval and the later sort of extension of approval. That's a case where the Solicitor General has appealed another Fifth Circuit decision, and I think almost without question the court will have to take up that case, and that's going to be an interesting dynamic this term.
Jess, does it sound like the court's taking a breather actually from the last 2 years if you compare the sort of blockbuster nature of these previous terms? This term sounds more like a normal court term where they're deciding cases where the government lost below, or the SG is asking for cert, or resolving conflicts about internal workings of the government.
Well, right. I mean, we don't have these sort of major social policy cases up there. We don't, we don't have any major religion cases, for example, this year being another area that the court has been very active in recent terms, but so far not this year. But I wouldn't downplay the importance of these administrative law cases to the conservatives who are now in the court, because many of them, their critique of 20th century jurisprudence also included the way that the court in those decades looked at federal power and the discretion of Congress and federal agencies. And this is a court where I think if you pull back to reveal what is animating this, there is, I think, a very strong property rights inclination of the majority on the court, that they believe, if you look at what is a common thing, they think it should be harder to impinge on private property rights, that agencies should not be able to do that as easily as they can, that people who find their property rights, or companies that find their property rights in some ways threatened or undermined, should have a greater opportunity to challenge that. That, I think, is one way to think about what unites a number of these cases. They just believe that the court in the past has been too cavalier about that particular set of rights, and that's why they want to see more, as we've seen in recent cases, they want to see more specific assertions by Congress that it intends to burden property rights in a certain way before allowing executive agencies to do it. But these are not issues that certainly get my editors that excited, even though we are a business paper. I hope Greg is luckier than I am in that area. But to the extent that it is a breather, we talk about things being thrust upon the court. Adam mentioned whether President Trump is or isn't disqualified for insurrectioning. There are other Trump-related matters in state and federal courts that also might give rise to appeals to the Supreme Court. And it is quite possible that next year, as the criminal proceedings move forward, as the civil proceeding in New York State Court, which just had a very unfavorable decision against the Trump organization this week, as those proceedings move forward, President Trump has not been shy about seeking remedies from the Supreme Court. He hasn't been too successful so far, but I think that we could see a lot of effort from him to get issues, should he be losing in the lower courts, up before the Supreme Court. So I could imagine a lot of Trump-related litigation beginning to sort of overshadow the otherwise very exciting issue of fisheries inspectors being placed upon certain maritime vessels coming up. And again, we do have there are a number of these social media cases which touch people, but so far, yeah, it is a breather in the sense of I don't think we're going to see a lot of people, marching with, Chevron logos on their placards outside the Supreme Court based on the major cases this term.
Yeah, just one point of observation on Justice's point is, this is an area where the court has been trying to withdraw itself, is the previous court's intrusion into the political process and the elections. Right? The field of election law didn't exist 30 years ago. Now it's a class taught at many law schools because of the court's activity. And the question whether the Roberts Court will continue its withdrawal is an interesting one. I think we'll see this year because, as you say, the election is going to drive these cases up to the court one way or the other.
John, on election law? Oh, sorry, go ahead, John.
Go ahead,
Well, I
Jen.
was going to say, can't the social cases, though, also be conceived of the same way, right? I mean, when the court weighed in to suggest there was all the substantive content in the due process clause, or in other rulings, taking a role in the social issues, and now I think that has been peeled back in both Dobbs and Harvard UNC.
But also at the same time, as Justice pointed out, in the property rights area, it's
Yeah, but I
become very
can
Second
conceive of
Amendment
it differently
area.
because I think they're thinking more of it as a threshold. They think the federal government has expanded its power beyond what it's been authorized to do in the Constitution. So it's not some individual rights protection. It's that the government was never intended to engage in that activity in the first place. So it has a practical bottom line of impacting our private ability and freedom, but it's not an individual rights thing as much as structurally. I think the court thinks agencies and Congress sometimes are overstepping what they're supposed to be doing.
And on that point, actually,
Adam?
even within the six conservative justices, they're often now ending up in the same place in these big cases involving administrative overreach. But there are some interesting differences in focus, I think, in the justices. And I don't want to overstate this because, like I said, they end up in the same place. But Justice Thomas, Justice Gorsuch, their big opinions on administrative overreach are about Congress delegating away its power, Congress stepping into areas where the states ought to be preeminent. It's about those fundamental separation of powers issues. I don't know that, well, I'd say Chief Justice Roberts, he agrees with a lot or all of that maybe, a lot of it. But oftentimes when he's writing the opinion, he's focused on the problem of just the ruinous uncertainty of agency flip-flops over time. Even in cases where he rules with Democratic appointed justices, like King v. Burwell, which involved Chevron deference and the Affordable Care Act, cases involving the census citizenship question in the Trump administration, the repeal of DACA. In those cases, Roberts writes for a majority of the justices, and either in the opinions or at oral argument, he really is focused on the pace of change in the administrative process and the ways in which radical changes from one administration to the next have disruptive effects. Now again, Roberts also joined Gorsuch's now famous dissent in Gundy, the non-delegation case. So Roberts was there too. But where he's taken the pen, it's often about the pace of change in administration and the problems of uncertainty. I used to keep quotes of his from oral argument from over the years in the Obama and then Trump and now Biden administrations, where he would needle Justice Department lawyers over, well, why did you change this policy? Why did the government change? And the agency would say, well, we learned more about the world. We thought harder about the statute. And Roberts would say, no, there was a presidential election. That's why you changed. And Roberts, maybe it's because he represented private industry and sees the costs of that kind of regulatory whiplash. I don't know. And again, I'm probably overstating all of this, but he seems really focused on that in an interesting way. And just while I'm filibustering, one last thing. On the election law stuff, Since the Roberts Court has made clear they don't want trial courts mucking around in elections at the last minute, it's called the Purcell Doctrine. They don't, and it's ambiguous when is too close to an election for the courts not to intervene. Well, that line of decisions from the court means that activists who want to get the courts into the election process are going to have to move 6 months sooner. And so we might see a lot of cases popping up between now and December, the kind of cases we would have expected to see January to April.
Well, we do have a significant one from South Carolina that's coming up, next month, which is similar in the facts to the Alabama redistricting case, although I think it comes up under the 14th Amendment instead of the Voting Rights Act. So I think the message of get these cases in early got out there.
So again, you're all wrong. The really important case is about the income tax. There is this one weird case I'll mention called Moore, which has been in the papers a little bit, where believe it or not, the Supreme Court has never definitively defined what is income for purposes of the income tax amendment. And this is of great importance now because trillions of dollars are at stake if the federal government or Congress could somehow use the income tax to tax wealth. Right? There are lots of proposals to tax wealth out there. The court's never really explained what's income and what's wealth. And so that's a sleeper case out there that might be so important in a term where there's no abortion, no guns, no right, affirmative action.
It's the most Bloomberg Wall Street Journal
Yeah,
case ever.
I'm surprised neither of you guys mentioned this. So
Behind the paywall. Yeah.
any 14-year-old kid can get around that thing. So here, let's maybe turn to our daily journalist first, maybe, to ask another important question, which is, it's, of course, undeniable there's more political scrutiny, criticism, and attention on the justices as individuals. There have been a series of stories about Justice Thomas, Justice Alito, Justice Gorsuch, and also even Justice Sotomayor about their personal finances, about trips, gifts, and so on. Personally, I think these are an effort to put pressure on the court, but that's just my personal view. Jess, what do you think about this? What do you think is the source of these criticisms? Do you think it's an effort to try to pressure the court in terms of its decisions? And maybe most importantly, do you think this is having an effect on the way the justices are acting or interacting with each other or interacting with the public?
Well, to pull back, the background is that the Supreme Court, while many people, I don't know if the court itself believes this, but many people believe it is bound by federal ethics statutes that set certain rules for disclosures and bribery and whatnot. It does not have a more elaborate code of conduct that specifies in greater detail what is permissible and impermissible conduct for a judge, or sort of an independent office or ombudsman to advise the justices on what's okay and what's not, so there are consistent standards. Lower federal courts do have a code like that and an office of ethics that advises them and puts out opinions that's supposed to have a uniform application throughout the federal courts. I'm sure every or nearly every state court system has a similar elaborate rules for conduct. Now, obviously, they don't always work, but they make that effort. Supreme Court does not, and for many years, it was really a bipartisan. You could look at it as a push, or from members of Congress, or annoyance that justices were not held to the same types of very specific rules that members of Congress and executive branch officials are held to. But we would see bipartisan bills introduced to require or urge or direct the court to adopt a code of conduct. So in fact, as recently as December of last year, the final House Judiciary Committee hearing, Congressman Issa, Congressman Gates joined several Democrats in saying that, why doesn't the Supreme Court have a code of conduct? It's not fair. We have to put up with this. Why don't they? Was sort of the tenor of those comments. This year, however, as I'm sure most of us know, there have been a number of investigative stories in ProPublica and some also in the AP and the New York Times and some other publications that have detailed with tremendous color some of the activities of some of the justices. And so, as John mentioned, there was a story about Justice Sotomayor's staff, Chambers aide, encouraging sponsors to buy copies of her book, her children's book, when she went to make an appearance. There was some questions about real estate transactions involving Justice Gorsuch. There was a report on a trip that Justice Alito took at the expense of a billionaire, Paul Singer, in 2008 to go fishing in Alaska. So there have been a number of these, but by far the greatest number of articles has focused on, and I say this as a member of the Clarence Thomas wing of the panel here, that on Justice Thomas, and what seems to be much more activity and much more, many more contacts, much more largesse accepted by a much more intimate relationship with very wealthy individuals, with, if not directly having cases in front of the court, at least a broader agenda before the Supreme Court. And so there's been, yes, they've, even the late Justice Ginsburg has been called out for certain things. There, you can nitpick and you can find things with almost anybody, but the real focus has been on what Justice Thomas has done and chosen not to disclose over the past years, and that's really what the scrutiny is. Now, is it? Are some of the particularly Democratic senators who also disagree with almost everything Justice Thomas has written? Are they? Is it a coincidence that he also happens to be the one doing these things, or are they somehow turning a blind eye to similar types of activities by other justices? Well, we haven't seen similar types of activities really of the scale that Justice Thomas has undertaken, and he's had a lot of explanations about why his disclosure forms were not complete or didn't include this or that. There have been a lot of them, like, oh, I didn't realize I had to report this, or another justice told me I didn't have to, or I was inadvertent not to do. There were a lot of reasons. And so, what does that mean? I mean, is it possible that it's both? They want to discredit what the court is doing, and they also are concerned about these activities. Would they turn a blind eye if it were a more liberal justice who was, taking a bunch of trips on George Soros's yacht? I don't know. But that's really the issue, and it clearly is hanging over the court. Justices are asked about it all the time when people have a chance to. Even very friendly interviewers ask them about it when they speak at circuit conferences. And several justices have said they hope that the court will take some step to do something about its conduct rules, including not only Justice Kagan, but Justice Kavanaugh and the Chief Justice. So what does that mean? It can't be good for the court, even for there to be questions like this. And I think that some people ask, is this a problem? Is this a Supreme Court issue? Is it a Justice Thomas issue? That's, I think, sort of the question. And again, with the judiciary, we talk about the appearance as well as the substance. No one is accusing Justice Thomas of having a bunch of gold bars in his freezer or whatever, as some members of the other branch, or at least one member of the other branch, is accused of doing. Nevertheless, what is it, and what is going on there?
Great. So let me also add, to me at least, it's hard for me to be moderate about this. It looks like more of a pattern of criticism of the court, because it follows the previous year where you had the unprecedented leak of a Supreme Court majority opinion, and not just an opinion, but Dobbs.
Threats and
I
attempts.
was just about getting to that, and then an effort to kill Justice Kavanaugh, and the year before that, a commission to study whether to add justices to the Supreme Court. So, do you agree with that, or do you think it's more episodic, that's not part of this larger trend? By the way, we still don't know who leaked the Dobbs opinion. It's been over a year, and there was an investigation. Looks like whoever leaked it got away with it in their effort to pressure the court to change its mind, or maybe to stick to its original position, whatever the leaker's intentions were.
Well, I would draw some pretty sharp distinctions among the things that you and Jen listed there. Assassination attempts, clearly on one absolute extreme.
Was it reported on as much as the recent stories? I didn't mean to cut you off. That's not for you. That's for the audience to consider. If it is more important, was it reported on more vigorously? Anyway, keep going.
Yeah. So that's happy to discuss that. The issue of adding members to the court combination of A, like, of course that's not going to happen anytime soon, it's a political reality, but B, it's a perfectly appropriate thing for people to be discussing. There's nothing wrong with people who saying, I think there ought to be more justices on the court, and here's why. And then there are things in the middle. The leak of the Dobbs opinion, obviously huge breach of the court's protocols, and we don't know who did that. And I have, pretty much from the get-go felt like I don't actually, no theory of who leaked it makes good sense to me. I don't know who leaked it. I know people have different views. Justice Alito has, suggested very strongly publicly that it is from somebody on the left side, or somebody who was unhappy with the Dobbs decision. So I'm not sure kind of where that fits in terms of being criticism of the court. In terms of, I think I agree with kind of the way I think I was happy that you turned to Jess first to sort of lay out those issues, because I thought he did a very able job of them. I think some of these stories about these ethics issues, some are clearly more important than others. And I think some of the stories that have come out, you kind of look at it and, I don't want to criticize my colleagues' work, but some of them you're like, I'm not sure there's anything there, and I'm not sure why this story is out there. I think this is unquestionably, and last thing I'll say is I will associate myself with what Jess said about there is an alignment between people who are critical of, who don't like the Dobbs decision, the Bruin decision, and all those, and what has happened with the court, and don't like how we ended up with this alignment of justices, and the people who are critical of Justice Thomas for his activities. I don't know that you necessarily have to say because of that alignment, we're not going to look at the story, the allegations, his response to it, and actually talk about that as a serious issue.
I mean, I would say the other way to look at it, John, is to say, is the alignment between people who support Justice Thomas and their failure to criticize some of this behavior, equally influenced by their views? I mean, we do know that when an item came up with Justice Sotomayor, Senator Whitehouse, a very vocal critic of the Supreme Court, called her out on it and said it was inexcusable, and that's another. And he said there's further reason that they need to have a code of conduct. We haven't seen Republican senators. They've said they wish. Some of them have said we wish the court would take care of this problem. I mean, Senator Graham, Senator Grassley have suggested that they're not in favor of legislation, but it would really be a great thing if the court would clean up its act on its own. So in a sense, there is general bipartisan concern about this. But if the same conduct was taking place with another justice, would sort of the silence on the right regarding what we've learned about Justice Thomas's relationships be as silent? I mean, I think that's as much a correlation that you have to ask about. Jen?
I mean, don't we know that? I mean, for years, there have been justices on both sides engaging and going, for example, hanging out at various conventions with folks who have a very clear view of the law. And so I think the reason that the attention is where it is right now is because there's a particular organization. It's funded by folks we don't even exactly know, who's taking a concerted effort to peel back actions taken by one individual. And there's actually, when we say allegation of wrongdoing, there actually is there's a lot of smoke, I think, sometimes, and not a lot of, what is the wrongdoing? Making the mistakes on forms, which now have been addressed. So, and again, I do think this is just one more topic that's being engaged in to try to question atmospherics around the court, whether they're legitimate ones of can we increase the number of justices, or whether it's assassination attempts, or whether it's members of other branches, going to the steps of the Supreme Court and expressing views about the decisions. It's just stories about things happening within the building that really have nothing at the end of the day to do with the Supreme Court's actual role in deciding cases and applying the law. And even with this latest round of category of stories, there's nothing at all coming out that has anything actually to do with the Supreme Court doing its job and deciding cases and whether it is or is not accurately applying the Constitution and statutes to cases before it. There hasn't been a single accusation that there's been something done that's been awry or wrong or incorrect in that space. So I think it's a lot of atmospherics. One, because it's maybe perceived as more interesting, and also I think there is reason to think sometimes folks are trying to undermine now the particular institution of the Supreme Court, at other times in our history, other institutions with authority and trust, and sometimes a general cynicism that we're allowing to creep in.
Can I throw in on this?
Yes, go ahead,
And I'll just,
Adam.
speaking as somebody who was serving on that presidential commission to consider court packing, I could say, first of all, I think it would be ruinous if we decided that Congress was going to be in charge of day-to-day oversight of the Supreme Court and lower courts, and bring judges before it to answer questions about the cases and about allegations about the justices. I know Congress thinks its main job now is being the People's Court sitting in judgment of agencies or the administration or the administration's critics. All Congress wants to do is sit there and have these hearings about other people. And that's one thing when it comes to administration. I mean, the president has the executive power, so in a sense, he kind of works for Congress, not really, but he's executing Congress's laws, and I can see the oversight function there. Putting Congress in sort of constant oversight of the courts would be a constitutional disaster for all reasons that the founders understood and reasons we can see clearly in our own time. And I feel the same way about proposals to change the court. The newest one is I think it's Congressman Schiff has a proposal to designate certain justices who have been around for a long time as senior justices who get basically relieved of their duty. I mean, we studied this on the court commission, and this is blatantly unconstitutional, in my opinion. We didn't reach conclusions in the report, but I'll say for myself, blatantly unconstitutional. And it's even proposals to add justices to the court. It's never proposed in terms of, will adding more justices make the court a better court, right? 9 justices admittedly is arbitrary. Maybe if we always had 7 justices, that might be fine. Maybe if we always had 11 justices, that would be fine. Nothing magical about the number 9, but we've had it for a long time. And none of the proposals to add more justices would make the court better as a court. It's always in terms of people's views of the decisions of this court. And in an era, as Jen said, when all of our constitutional institutions are under a profound attack from one direction or another, that's what these reform proposals are. Now, in terms of ethics rules for the Supreme Court, we should not accept Congress prescribing these rules for the independent federal judiciary. To the extent that the justices themselves decide this would be a good thing to make them better as a court, I'm open to that. I think if they do it, they ought to do it for the lower courts too, and not have this sort of bifurcated thing where the lower courts' rules are prescribed by Congress, the Supreme Court's rules are prescribed by the Supreme Court. I understand the theoretical reasons for that distinction, but I don't think they really hold. I think that if this is going to happen, it ought to happen within the court as the head of our judicial institutions, taking care of itself, rather than Congress asserting dominance over the courts.
Well, we're almost at the end of the time, and I want to reserve a significant amount for questions. So I'm going to dispense with my last set of questions and just go right to the audience. Just one observation on the Thomas thing is, and I think Jen hit on this too, is the implication of these kind of accusations is that someone received gifts and they did something in exchange for the gift, a quid pro quo. As someone who clerked for Justice Thomas in his earlier years on the court, I find him, of the justices on the court, the person who's least interested or affected by what goes on outside the court and reaching his decisions. I would actually put at the far end, on the other side, Chief Justice Roberts, who I think does try to be conscious of the political circumstances of the decisions. I think sometimes he, for example, in the Obamacare case, will change his view in response to political pressure. This is the thing I think that's unusual about these attacks is I think Justice Thomas is the one who's least susceptible to this kind of pressure. So I find it, I think it's a campaign that's going to be remarkably unsuccessful because of the particular person it happens to be aimed
clear,
at.
it sounds like you're talking about pressure. The stories on the outside are trying to get him to change what he's doing because they don't like his decisions, and you're just saying he won't be successful.
Yeah, I think he's, I'm not the only person to make this observation.
Right.
Since he's the most committed originalist, he gives himself the least ability to actually change what he thinks or does.
But you're not.
I think he once said you were even more an originalist than him.
On the court, I said. He's the most originalist on the court. I'm more originalist than him.
But John, the smoke around the attacks is suggesting that it's whatever the gifts or the trips were that's somehow influencing his votes, and there's actually never really been even a tangible accusation of that. It's that the stories are there giving all these facts, and then you're left to sort of infer, well, the reason these must be wrong is because they must be impacting votes. And there's not even any, with all the research being done, suggestion or hint that that's ever occurred or even thought of.
I just have to say, I do not think that is what the stories are saying. I think that the actual, I mean, I'm talking not about polemics that spin off of the actual investigative reporting. I think the reports, particularly in ProPublica, they are saying, there are rules that suggest that federal judges need to disclose certain types of things they receive from others. And it doesn't say that there has to be a bribe. It doesn't say anything about that. It says they have to disclose them. And the interpretations and the failure to disclose, particularly because Justice Thomas used to have a practice of disclosing things he accepted from Harlan Crow and stopped in 2004 after the Los Angeles Times wrote a story looking at the disclosure form saying, gee, he seems to be taking a lot of free trips given to him by this billionaire. And after they wrote that story, he stopped disclosing it, but he continued to accept them. So the question really is there, should there be disclosure or not? He says many reasons why there shouldn't be. That is, no, I have not seen any suggestion that he's being bought. I think the suggestion is the concept behind these disclosure rules is so the public has an idea who is giving things to federal judges. And what you make of it, Justice Ginsburg was criticized for certain gifts that she accepted, but the reason we know and we're able to criticize them is because she disclosed them. And so that's really I think the issue here. And you could say, well, if I were a newspaper editor, I wouldn't have published that story. I wouldn't consider it newsworthy. I think it is newsworthy. I think it is per se newsworthy. And if people, and that is not, I don't think it has to rise to the level of an actual bribe to be newsworthy.
Correct.
I was going to make a slightly different point, which is I think the reason that these Justice Thomas stories have taken off is it's all about the appearance. It is actually not, the disclosure is really important because, the question is, the idea of disclosure is, if you have to disclose a trip like this, maybe you don't take it because you're concerned about how it would look. The reason this became a big thing was because it is, these lavish trips, friendships that started after he became a justice, Leonard Leo being a part of these trips sometimes and, being there. And, it just makes people, think just on those facts that they have thoughts, and some people aren't bothered by it, okay. And some people say, I'm uncomfortable with this idea that a justice seems to be getting this personal benefit from his time, from these people who were not his friends beforehand. And so I think that's why it's really sort of taken off. And, I actually agree. Yeah, we probably, probably more stories should have been written about Justice Ginsburg back back in the day.
Or any of the really, I mean, if it's going to be that metric, right? What relationships were formed? Who are the justices spending time with? Every single overseas trip, every conference, every dinner with an elite intellectual should be reported on, and I guarantee, and we know over the years, there are scores of those with justices all across the range of the court. And so I think this is why it's really important to parse out precisely what the story is. If it's literally just a form violation, well, that's actually now been fixed, so that would mean the story's end.
Well,
if it's about the appearance and what it all means and whether we're comfortable with it, there are many, 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 many behaviors putting thinkers who we believe have certain views about cases in the same room with justices for decades and decades and decades, and it is not in any way the case that those stories have been proportionately reported on recently. But we're far afield of the actual upcoming Supreme Court term. John, anything more on the cases?
You're being a better moderator than I am. I was entranced to hear more. But why don't we turn it to questions? Just to give you an idea, my last question was going to be, which justice would you vote off the island? But they stole that from me last night at the debate. So if you have any questions, just raise your hand. I'll call on you. Right here, John. And wait for the microphone to come your way. Why don't you say who you are and which...
John Vecchione, New Civil Liberties Alliance. My question is, do you think they'll take... There is a property rights case, the rent control case that's coming out of New York. And I'll just give a quick...
Yeah,
there's rent control in New York, not a lot of other places, but it goes by whether or not there's a vacancy rate. And the vacancy rate has never gone up to the level where rent control stops. But during COVID, it did. So they changed the law so that rent control wouldn't stop. And that's the issue that's being asked to go up to the Supreme Court. It has all, I thought that it was an outlier, that there's no way, but now I've changed my mind. Does anyone think that they're interested in this issue and that they take it and that it would be a properties rights case?
We did not communicate beforehand about this, but this is a really interesting case. Also, because if I remember correctly, the original legal justification for rent control comes from the emergency conditions of World War II. And so it's one of the most long-lasting emergency regulations of the economy still in existence. But this goes to actually a point, is this a court that's interested in reinvigorating property rights in some way beyond the cases we've seen, which have been fairly technical involving environmental law? This is something much more significant. So, Adam, do you?
Well, it's the most. We know Richard Epstein, and this is surely the most Richard Epstein case in Supreme Court history. What I do know about the case is it has a lot of amicus support. It has, who's the lead counsel in the case? Andy Pincus? Andy Pincus. So the issue is getting sort of probably more thorough legal treatment than it's ever received, probably. And at a moment where the court has a lot of space on its docket, I wouldn't do like the odds on it, but I would just say it's probably more likely than ever before in any previous case that the court would take the case.
And also, the court did strike down the eviction moratorium, but on a different ground, on the ground that Congress hadn't authorized a nationwide ban on evictions, but sounds in the same property rights area.
Yeah, but in the other direction, I would say, just as John and Jen said earlier, the court has been backing itself out of a lot of sort of 14th Amendment theories. I'm not saying that these arguments about property rights here are the same as ones over right to privacy and so on. But to the extent that the court is backing away from sort of an assertive 14th Amendment jurisprudence generally, that's the trajectory of the court. And the court might want to take a breather in light of the last couple of years. Who knows, maybe they won't want to engage the case.
I also just want to note, there is a gun control case before the court. It's the gun control case is, I think a preliminary injunction was given. A preliminary injunction was given to take away someone's guns for domestic violence.
It's called Rahimi. It's the Rahimi case. Yeah,
That's another Fifth Circuit case.
Just were you about to say something about the rent control?
No, I mean, I agree. I think it's an issue that a lot of members of the court would be interested in, particularly, that there are fewer justices from New York now on the court. So, something that New York City would find difficult might be, more appealing to the court. Joking. But no, I think it's definitely better than the typical 100 to 1 odds of getting taken. And if there are more challenges to rent control in other circuits, because there are a few other places, in the Fourth Circuit, Ninth Circuit, where there are cities that have rent control. It might even, they might want to see if this takes off as a broader issue before they hear a case on it. But I'd say rent control would be an issue they might want to get to.
And we could find out as early as tomorrow.
Another question right here. While the microphone makes it over to here, I'll repeat, I think, a joke of Justice Scalia's, which was he was hoping there would be one more justice from New York so that each borough had its own justice on the Supreme Court. Because I think at one point there were 5 or 6 justices from New York
Staten
City.
Island,
Yeah.
what's the problem with them?
Please, right here.
Over the last...
Okay, say your name. And,
Gene Dorosh, just a retired citizen.
if you're a citizen, you're never retired.
That's true. Over the last 30 years or so, do you think that public trust in the Supreme Court is at a low ebb, and why?
Maybe the daily reports.
Well,
should
there's
keep eye on
an
this.
empirical answer to that. And the answer is yes, because there are polls that are taken, and all the polls, Pew, Gallup, all the reputable polls we look at, show that it is at the lowest point since they have been polling. So why that might be? We know the Dobbs decision was not a popular decision. The affirmative action case. I think this was a trend that happened really before the affirmative action case. That probably did not move the needle very much, but yes, it is lower. Is it? But why? The polls don't seem to really get into why, so there's more speculation. But probably a general lowering of respect for institutions is part of it. Part of it may be, particularly among Democrats, unhappy with the very clear conservative tilt of the court, because Democrats and independents, their opinion of the court has fallen more than Republicans, although Republicans has also either stayed or fallen, but Democrats and independents, it's cratered. So why? Obviously, unhappiness with the results is part of it, but the polls themselves don't seem to really detail why. But we know it is lower.
Well, one way to evaluate whether it's institutions in general is to look at the poll numbers of others. And I'm looking at a Gallup page that says 17% of Americans approve of the job Congress is doing. So my vote's going to be that it's institutions across the board. And it says 41% approve of President Biden, 17% of Congress. It doesn't list the court, this particular page. But what's the latest court number?
It's like mid-40s, I think.
Okay, so that's better than Congress.
I think one thing that has
There-
happened is that the court has become viewed as more of an extension of the political process. And one fact I like to cite, because I feel so important to me, is when Justice Kagan joined the court in 2010, that was the moment when, for the first time, all the most liberal justices were appointed by Democratic presidents and all the most conservative were appointed by Republican presidents. Both parties view the court as a means of furthering their agendas, and they are now much better than they used to be when David Souter was selected at identifying justices who, for the most part, will cast votes that they like. And I've always been somebody who thought it's useful to identify a justice as appointed by a Democrat or appointed by a Republican. But now it's really important because that actually tells you an awful lot about them. And on those occasions when they vote against type, I think that's also very noteworthy. But we have this court where kind of almost by definition, half the country is not going to like, because at this point in time, it is dominated by Republican appointees who are more often than not going to be, voting in a way that advances an agenda that one half of the country likes and the other half doesn't.
I would just add, as Jess said, when you look into the crosstabs of these polls about where the decline in the court's, call it approval rating or whatever, favorability rating is going down, it's going down dramatic. It went down dramatically among Democrats, unsurprisingly. It's stayed about the same or gone up among Republicans, I can't remember. And then among independents in the polls I've seen, it's gone down. Not as much as among Democrats, but it's gone down. And that's an interesting question of why is that? First of all, given that the court's critics, partisan critics, have tried to talk us into a legitimacy crisis about the Supreme Court. Of course, lay observers who are reading more and more stories about, oh, the court is corrupt or illegitimate or out of touch with the people. Of course, people who aren't following it that closely are going to be affected in a negative direction, just on the availability of the articles they're reading. Second, to the extent that they're, you said they're viewing the court as an extension of the political process, to the extent they're viewing the court at all, probably doesn't help the court's approval ratings, in the sense that in a well-functioning republic, you wouldn't hear that much about the Supreme Court, right? It wouldn't be deciding big issues. It wouldn't be called upon to decide big issues. It's only because the political branches and others are overstepping their bounds that the court is dragged into contentious disputes. And you add on top of that our modern media environment. I don't mean the good folks at the Journal and Bloomberg, but I just mean the social media environment, other things. We're arguing about things in soundbite size more and more. And we're becoming more dissatisfied, not just with all institutions, but with everything. So of course the court's approval ratings are going to go down. And so that's not to say that the people aren't just reaching well-founded judgments about the court, finding they disagree with the court on important issues, and saying, I don't like the court as much as I used to. That surely is part of it too. Of course, the point of the court is not to respond to those trends, but to make the decisions independently and neutrally in the most judicial way possible.
Two quick thoughts. One is, if the court's doing its job properly, it should have a low approval rating. Because whenever it does something momentous, it's telling the majority you're not allowed to do something. And if it's approving what the majority does, we don't really need the Supreme Court around. We could be like England or the United Kingdom. Second point is, this is not something new. If you look at these other momentous periods in our history, the founding period, the Civil War, and the New Deal period, the Supreme Court was also similarly, I think, held in low regard by the majority of the people and did become caught up in partisan politics. That's why I was asking, is this a pivotal point for the Roberts Court? Because in all those examples, you do see the court change direction and go off into new areas or different approaches to interpretation as a result of that kind of crucible, political crucible. So I wonder if that's what we're going through now. I can't tell. There was a question right behind you, right there. No? Yeah, there you go.
Hi, I'm Jack. I'm a future law student, so not quite yet.
Do they deprive future law students of last names? Or?
I'm Jack Gomer.
There you go.
I was in your summer honors class. I'm not sure.
Oh my God, now I have bad memory.
The case I care most about, because I think it's the most interesting, is the upcoming Rahimi case. I know you guys touch on it a little bit, yes. But I read the Fifth Circuit decision, and I'm not entirely sure the Supreme Court is going to agree with them, and I was just wondering what your thoughts on this are. Bruen was 6-3 along ideological lines, and I know, like many media, a lot of the media is concerned this is going to be another conservative takeover, but I'm not so convinced. I know Justice Barrett, in her time on the Seventh Circuit, she wrote a really good dissent about like depriving dangerous people of their Second Amendment rights. So I was wondering if you guys think this is going to be one of those cases where like the Roberts, Kavanaugh, Barrett contingency swings a little bit more with the liberals, and if the Rahimi case is going to divide along the Bruen lines, or it's going to look a little bit different.
Well, I take full credit for the brilliance of your question, since you were my student. So for those who are not following, Rahimi is the case that Greg first alluded to, John alluded to it. This is the question whether your right to have a gun can be regulated or even taken away if you're subject to a domestic violence order. And it might raise the question, what does the right to bear arms identified in Bruen and McDonald and Heller, what does it mean when you look at more modern regulation of gun rights? So, Jen, did you want to talk about this? Your thoughts about, or anybody else have some?
Well, I'll just quickly say, if we have a little bit of time, that this case was brought by the government. Okay, the United States is appealing the Fifth Circuit decision, and so they, expect to, if they're the ones bringing it, you could say, well, they have no choice, they have to defend a federal statute, but I think they have some confidence that that if the court, that if people thought, or if the court thought it meant in Bruen that you had to have a domestic abuser statute in 1790s, Rhode Island in order to justify one today, that the court didn't mean that. That when that they think that when you have an adjudication, there's a court order, they'll be able to pass it. So it may not turn out the same way that Bruin did. Certainly the government obviously thinks that it
And he's
won't.
really not a very sympathetic party. I mean, multiple problems with guns possession. So I'm sure that's also weighing in strategically.
And actually a finding by a judge that that he was dangerous, I believe.
Adam, any?
No, that covers it.
Yep. So just to give the context, what everyone's referring to is in Bruin, the court said a regulation to be constitutional now has to have some kind of analog to a regulation of guns that existed at the time of the ratification of the Second Amendment, although you could modify that some for if this is something that applies to the states. The understanding of gun regulation existed at the time of the ratification of the 14th Amendment, which is the amendment that incorporates the Second Amendment to the states. So those could actually be different, because Jess raised this is a federal case. It might be the case that states have greater leeway than the federal government to regulate firearms under the way the Supreme Court has identified the test. There's another question right here.
Hi, my name is Andrew Zach. I work at the DOJ. I'm also one of John's former students.
I did not actually send out an email saying, come one, come all for free lunch.
Credit.
So I think it's become clear in the last couple of years that, especially as originalists have become kind of the majority or a strong majority on the court, that there are a lot of, I'd say, methodological disagreements within that camp. And I think you've talked about this a little bit on the panel today, but I was just kind of curious if you think there are cases where those kind of methodological disagreements you think will come to a head or that are particularly ripe for disagreement among the originalists on the court.
Well, so one are there strong methodological disagreements, and then what effect is this having? Adam, why don't you start? Oh, wait, Jen, you want to go first?
I mean, just,
go
well, I
ahead.
was just going to say, I mean, I think the biggest distinction is how they all treat precedent and how much room they would take to apply originalism in a given case. And then I also do think that there are those who adhere more to the text, history, and tradition line as opposed to just text and history. But I think it's really the pragmatics of folks who don't want to totally uproot and go all the way back.
I'd agree completely with that. And I would just say, on the issue, the way you phrase the question, there are going to be disagreements. In that respect, in many ways, the most consequential justice is Justice Kagan. She's the first modern progressive, or she's the first progressive or Democratic appointed justice in the modern era to really speak textualist as a first language. And so she's, I think, uniquely well positioned to identify subtle, latent disagreements at the prudential level between conservative justices and sort of get in there like a wedge and actually force justices to explicitly grapple with and decide subtle disagreements that otherwise might have remained implicit or latent. I think the most famous example of that now is the Bostock case, the Civil Rights Act case, but I think we'll see more cases like that. I've always, to Jen's point, which I agree with completely, Justice Alito several times would say, I always begin with originalism. And I think that's a good way of thinking about, to the extent there's disagreements among the conservative justices, it is that point that Jen made about how does precedent come into play, how do questions about maybe foggier notions of judicial restraint and leaving some room for space in the states, for states to experiment a little bit. We saw this in the disagreements 10 years ago between Justice Alito and Scalia on free speech issues, in the video game case, and the funeral protest case, and the animal crush videos case. But those cases really are the exceptions, I think, not the rules. We shouldn't overstate the disagreements.
I think one more methodological problem that will come up is sometimes when they're pinged these big questions, some are concerned about uprooting past precedent if they don't have an alternative view to put in its place. So like with the adoption, Fulton case, for example, I think Justice Barrett and Justice Kavanaugh were concerned we don't have something to replace employment division versus Smith. I think this might come up, not to go back to the ad law hat, but in the delegation questions, nobody wants to uproot the vague, intelligible principle test. And so they're sometimes not wanting to issue constitutional rulings in areas where the answer is obvious in that case, but they don't have a new agreed-upon test to govern the lower courts moving on. And Justice Kavanaugh, in particular, in his separate writings, has told us that he's concerned to be very clear to the public and the lower courts what the Supreme Court's doing. And so I think he, in particular, and maybe Justice Barrett as well, is hesitant to weigh in much of a too broad-based way until they've agreed upon a pragmatic way to operationalize these tests moving forward.
I might summarize all this in part by saying it's a lot cleaner to use originalism with the Second Amendment, where you don't have 200 years of precedent interpreting it.
Yeah.
And then we could, there are disagreements, or maybe we'll see them about, what does history and tradition mean? Maybe we'll see some of those. But the First Amendment, like, nobody is talking about going back and talking about what they actually meant with the free speech clause in 1789, or at least not spending that much time in it, because there is all this precedent that you're going to have to deal with if you're going to say, oh, actually, we have a different interpretation.
Although, as Justice Thomas said once, 20 years ago in an opinion, he was suggesting the court should overturn some precedent from like 1806. He said something along the lines of, well, just because we've done something wrong for 200 years doesn't mean we should keep doing it wrong.
I withdraw the word nobody.
Okay.
There are, but it's a lot. It is almost I think that's what both of you were saying.
A recent precedent like 1806 really is entitled to no weight.
Well, we're at almost exactly the end of time. So thank you very much to the audience for your great questions, and let's thank our panelists. We are adjourned. Thank you.